Okay, so today we're going to be doing a webinar on child custody in Washington State, and I'll be joined in just a moment by Michelle Dellino from Dellino Family Law Group. I'll briefly introduce myself. My name is Melissa Rosenberg, and I'm a therapist here in Seattle, operating a private practice with the specialty area of working with clients dealing with various stages of divorce and separation. I work with both individuals and couples who are navigating, the next steps of their relationship, trying to determine if divorce or separation might be the right path for them. I work with people who are in the middle of their complicated family law case. And I also work with people on the other end who are trying to pick up the pieces and move into their next chapter of life. But today I am here as a moderator for this webinar. And I'm going to turn it over to Michelle. She'll introduce herself in just a moment, but just a couple quick things about how this webinar is going to work. Michelle's going to deliver a whole bunch of great information about child custody in Washington State. And we also are here to field some questions if you're interested in asking things as it comes up over this next hour. The way that you ask questions, two options. You can go to the Q&A at the bottom of the Zoom screen and go ahead and put a question in there. Just to let you know, your name will pop up in the question and answer unless you mark yourself as an anonymous attendee. So that's also an option. And the other option is that you can ask a question on the chat. And I'm setting it up right now so that attendees can only chat with me. So those questions will only come to me. So any questions that come out, I will pitch to Michelle. We'll try to get as many of those answered as possible and hopefully leave you guys here, equipped with a lot of great info. All right, so I'll turn it over now to Michelle to go ahead and introduce herself.
Hi, thanks for being here. I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue. We help clients with divorce, custody, all kinds of family law issues all over Washington State. We specifically help clients in King, Pierce, Snohomish, and Kitsap counties, but we also do go to other counties as well. So anyway, thanks for being here today. We're going to talk about something important today, custody. Custody is kind of like at the heart of your case, if you have children, whether it's a divorce or whether it's another kind of family law action that involves custody. So it's also one of the areas that I think is the most, I would say, for lack of a better word, stressful and triggering for people, because you kind of wonder, gosh, we've been living together with our child or children. Now we're living apart. Where's my child going to be? When am I going to see them? What's that going to look like? The other party's going to say really bad things about me. Are they going to try to take time away from me? Like, there's all kinds of fear that is, I think, a big part of what happens in custody situations. So what I'm going to talk about today, just so you kind of know what to expect, I'm going to talk about custody in the divorce context. I'm going to talk about custody basics, like what Washington courts actually consider, what the factors are, because it's very easy to say, oh, I'm a good parent, I should have the kid all the time. And that it doesn't mean anything if it doesn't fit into the factors that the court's going to consider. So I'm going to talk about limiting factors, which can include domestic violence, substance abuse, and other things like that. And then hopefully I will stop several times. And if you have questions, you can, as Melissa explained, pitch them to her and she will ask them and I'll do my best to answer them. A couple of things before we get started, though. I'm an attorney, but I'm not your attorney unless you have specifically retained me. Nothing that I say here should be construed as legal advice. It's really just basic information. If you have a lot of questions that are very fact specific, which is a normal thing to want to be like, okay, here's a hypothetical, what do I do? That's not abnormal, but it's really difficult to answer those kinds of questions. And you should probably get a consultation with someone, even if it's not at our office, to get your specifics answered. So sometimes if you have a fact specific question, I will try to generalize it just to get some information out there. So I hope that helps. So let's just talk about custody in general. So custody is a word that everybody knows, but in some states, it's called a custody order or a custody agreement. In Washington, the most common document you are going to see is called a parenting plan. Washington uses somewhat more friendly terms, like we don't say alimony, we say spousal maintenance or spousal support. We don't say custody order, we say parenting plan. But essentially, there are two kinds of custody in Washington. There's physical custody and legal custody. Physical custody is who has the child living with them at a certain time or in their care. Legal custody is who is a legal parent, who has parental rights, who gets to make decisions for the child, who's the parent. So the legal parent. That doesn't necessarily mean you have the child with you at all times, because your child might be on residential time with the other parent. It doesn't mean you're not a parent and you don't get to get notified if something happens. So Anyway, those are two types of custody. But when we talk about custody orders and agreements, we're also talking about a parenting plan. So parenting plans look different depending on a child's needs and both parties' parenting abilities. That's one thing. A lot of times I'll see in these groups that a variety of people are in online that I might see someone's like, can you give me an example of what your parenting plan looks like so I can know how to draft it? That's the most ridiculous thing I've ever seen. And I try to just take it with a grain of salt because your parenting plan is not going to look like someone else's parenting plan. Sure, there are some standard provisions that we use, but your parenting plan, a good parenting plan, should focus on like what is fact specific to your child or children, the developmental situation with your child or children, what the schedule should look like, what the extra provisions should be. So anyway, it's not a one size fits all situation. In most cases, it's also important to think about what's realistic. I'll give you a little bit of background. When I started doing this about 15 years ago, it was very common for one parent, usually mom, but sometimes dad, but usually mom, to have the children most of the time, and dad would have every other weekend, maybe Friday to Sunday. And then as time went on, it became common for the other we call them the non-residential parent. It's called residential time. And so the parent who has less time is the non-residential parent. It would be more common for that parent then to have maybe Friday to Sunday and like a Wednesday dinner or a Wednesday overnight. And then as time went on a little further, it was kind of like, okay, weekends started looking like Friday to Monday. And maybe then that parent is responsible for getting the child back to school. So that's an extra night, right? And Wednesday usually would be an overnight. And then as time went on a little further, we're kind of come to where we are now, which is a more of a focus on equal parenting time. Unless there is what we would call a basis for restrictions. And we'll talk about that a little bit later. Or there's a distance issue, like a long distance parenting issue, or something that's just maybe not even long distance, but one person lives in Bellevue and the other person lives in Linwood. That's going to make it difficult to have equal parenting time because of schools. But unless there's a basis, there's more of a movement now that, you know what, people should be able to have time with the children, even if they weren't maybe the primary parent before, because courts recognize now, well, maybe I wasn't the primary parent because I was working, and now that's going to look different. So there's also developmental standards based on how old your child is and what that looks like. So it's not a one size all situation, but now very often if parents don't live very far from each other and there's not a basis for restrictions, one parent might not like it, but you might end up on a 50-50 schedule, or you might end up in a situation where your parenting plan steps up to more equal time as it's more developmentally appropriate. So that's something to know. Before I take some questions, I don't know if there are any yet, Melissa, but I will basically go over kind of the general factors that a court will consider. So parents often want a straightforward answer to the question, how is custody determined? How's the residential time determined? But the truth really is the answer, especially in Washington, is anything but simple. Every issue brought to the court will go to a temporary orders hearing if it's a temporary decision before a commissioner, and in a trial would go to a family law judge, and they'll decide on an agreement. And there are the bottom line though, and I'm going to put this out there, is 90% of cases don't end up there. Most of the time you will focus on a settlement in mediation or negotiation that's reflective of what might happen in court. And it really makes more sense, number one, to have some semblance of control over your situation, to negotiate a resolution, and number two, to save on the time and expense emotionally and financially of a trial. A family law trial is not a fun thing for anyone. There's really no winners. It is emotionally exhaustive, and it can make co-parenting really difficult afterwards. So most of the time, cases are resolved very often in mediation. But to make a determination of custody, I'll just talk very basically about some of the factors that are considered. One, the child's relationship with each parent. Two, the child's relationship with other siblings or individuals in somebody's household. Three, each parent's ability to care for the child. Four, physical, emotional, and mental health of each parent. Five, the children's involvement in their present community. And six, who was the primary caretaker in the past. And you might hear that and you might think, oh, well, I stayed home with the kids. Well, that's not determinative. It's just one factor. It's just one factor. The overarching theme really is what is in the best interest of the children. And these are some things that are considered. And you might be wondering, like, well, how does the court know these things? So for the court to know these things, oftentimes, if parties can't come to an agreement, there is a need for what I would call a custody evaluation. And that can be done multiple ways. It can either be done by family court services, which is probably what I would recommend if you don't have financial resources or if there are very limited issues, because the investigation done by Family Court Services takes longer and it's not going to be as nuanced or detailed or thorough as a guardian ad litem or a parenting evaluator might be. But Family Court Services is something that's available, and they're going to get involved if there's not private mediation, and they're going to get involved, and you might have a recommendation from them. Okay. Next is a guardian ad litem. A guardian ad litem is a person who has undergone training, that is on a registry, and can be appointed by the court either on a motion to the court or by agreement between the parties. That person is very often maybe an attorney, maybe a social worker, maybe a therapist, somebody that has relevant experience, that's gone through training, and that person is in a position to do an investigation. They'll talk to the parties, they'll talk to what we call collateral contacts, other therapists, counselors, other people that are involved that have personal knowledge of parenting of the parties, and they'll also observe the parent with the children and talk to the children, and they'll make a recommendation. Parenting evaluator is something very similar, but instead of really trying to stand in the shoes of the child like a guardian ad litem and make a recommendation, they are more intensively evaluating the parent's specific parenting abilities and their mental health, their psychological background. There's usually a psych eval involved, and these are PhD or PsyD level people doing these evaluations, which means they're more intensive, and they're more time consuming, and they're more expensive. And sometimes they're actually really necessary and very helpful. So if you're in a trial, you've probably most of the time had one of those kinds of evaluations done to assess where things are at. And I'm guessing, since we're about 15 minutes in, there's probably some questions. So I'll take a pause and ask Melissa if there are any before I go back to talking.
We do have a couple of questions. First question here asks if you could talk a little bit more about long distance parenting plans.
Yeah.
There's an example, if you have international family ties, could you ask for the child to spend like summer vacation in another country and still have 50-50 in the US for the rest of the year? Or would you maybe have to switch to a lower split during the school year? What might that look like?
Okay, I'll talk about, that's kind of fact specific, but let me just talk in general about long distance parenting plans. So
Yeah.
a long distance parenting plan is typically if one parent lives in another state, another part of the state, maybe another country, any number of things like that. So in a long distance parenting plan, you need a special schedule because you need recognition of the fact that you are not going to be able to live close enough to get your children to school and co-parent. Like if one parent lives in Texas and one parent lives in Washington, that's not going to happen. So it's very common in a long distance plan for one parent to have all the residential time, like during the school year, right? And the other parent might have, depending on, and this is where it becomes fact intensive. Like I've had clients that have been in California and they have the means, so they'll come up one weekend a month and have like a 3-day weekend with the child or a 4-day weekend with the child. Or every time there is a school holiday 3-day weekend, they get that weekend. They get, every spring break, every midwinter break, and then the parents will split the Christmas break, or there's different ways. But the non-residential parent, the long distance parent, then will get most of the summer. So, it's really a plan that strives to give that other parent as much time as you can, but recognizes that during the school year, the child's going to need to be where they're going to need to be. So, and the age of the child will often determine whether the child will travel like for one weekend a month, or whether the parent will come there. Very often the other parent will come to where the child is because the child's young and isn't going to fly unaccompanied, or that's cost prohibitive. So, it's not unreal. It's also not unrealistic to have a situation where it's not unrealistic to have a situation where you have 50-50 in the summer, but you have a different custody schedule during the year. That's not really though specific to long distance because, and I don't remember, this person was asking about international trips. If you have ties to other countries and it's a Hague Convention country, that's a very important determinative factor. If it's a Hague Convention country, and that just basically means a country that's a signer to the Hague Convention, which means that Washington and US parenting plans on custody orders are honored there. So if one parent ran to London and didn't want to return the kids, or ran to Germany and didn't want to return the kids, a Washington custody order could be enforced there and the children would have to be returned. If a child was taken to India or the Soviet Union, I'm sorry, former Soviet Union, then you would have trouble getting the child back because they are not necessarily signers. Most of Western Europe, Canada, most countries that people travel to are, but there are some, especially India, which is not, and that can present a problem. And so it's not abnormal to have a restriction on travel to non-Hague Convention countries in a parenting plan. So anyway, I hope that helps.
Thank you. Yeah, a few more questions here.
Sure.
What might be different for a 12-month-old, or non-school age, much younger children? At what age are typically is 50/50 schedule implemented, and what do they do about really small children?
Definitely not at that age, unless maybe there's older children, and even then, between the ages of, I think it's important for people to really understand that there are, there's standards that, and it's not to say that it's not to say that there aren't exceptions to all of these things, and it's not to say that this is the only way to do things. But a lot of the time, custody evaluators will look at what's developmentally appropriate. And that's really what a court wants to know, right? So when we talk about what's developmentally appropriate, we're talking about guidelines that have come up, and the Association of Family and Conciliation Courts, also known as the AFCC, puts out a set of guidelines that are very helpful, and they talk about the developmental stages and what is generally appropriate. And it's based on studies, and it's based on input from child psychologists and things like that. It's not just a because we said so type thing. So if you're looking at young children, like really infants, like up to 1 year, you have to understand that I believe the way that it's discussed, and I know this from doing it in practice, is that there is a need for attachment and psychological, physical attachment to caregivers, especially if you have somebody that is breastfeeding, if you have somebody that is, is taking a maternity leave and staying home with a parent. And it's not to say that both parents can't do that, but it's not likely that you're going to have a child who is not even a year old going back and forth 50/50. If the parents don't live together during that time, which is probably what's happening if you're going through a divorce or separation, it's going to be really important for that non-residential parent to also develop a relationship with the child and time with the child before having sole residential time. So it doesn't mean that dad, if it's dad or whatever parent it is, doesn't get time right away. But it means that it might be a phased up situation where they take them for a day, they take them for, every couple days for the afternoon, they provide care, or they have, an overnight. But at the end of the day, that's very different than a child who is starting to walk, who is already kind of through those initial formative stages. But even then, 50/50 schedules are typically not until a child is older, closer to school age. And the reason why is because of, what is developmentally appropriate. It's different if you have a toddler that might be going back and forth with a couple of siblings or a preschooler or a first grader. You might have a situation like that where it makes more sense. But also, too, it's worth noting that when you do have 50/50 schedules when a child is younger, that's not going to look like week on, week off, because that's too much time for either parent to be away from the children. That might look like what's called a 2-2-3 schedule. And this also has to assume that parents live close enough together to make this happen. 2 days with one parent, 2 days with another parent, and then a 3-day long weekend, and then it resets. And so 2-2-3, 2-2-3, every other week, somebody has the 3. And it's a rotating schedule. That's not an appropriate schedule for everyone. I don't even love that schedule unless the children are really young, because it's a lot of exchanges. When children are older, it makes sense to go to a different schedule, maybe a week on, week off, maybe a 2-2-5, 5-5. There's many different schedules that you can do on a 50/50. But when children are young, you're not going to have a 50/50 right away, and in most cases. And you're not going to have long stretches of time where a parent doesn't see the child and the child doesn't see the parent. So
Thank you.
I'll take one more and then I'll go through some more.
Okay. The participants saying I've read a lot of horror stories about guardian ad litems. What's your experience? How often do you need to actually dispute a guardian ad litem's report?
Sure. Here's the thing to know. in most every report, whether it's a guardian ad litem or parenting evaluator or FCS or CASA, which are court-appointed special advocates, if you income qualify, there's always gonna be one parent doesn't like it. I mean, so sure. And not always, but most of the time there's gonna be a parent that doesn't like it. Or sometimes both parents won't love it. But usually there's one parent that doesn't like it because it doesn't give them as much time as they want. And I mean, I'm not saying the guardian ad litems or parenting evaluators are perfect, because they're definitely not. And there's many times when we've had to, get another expert to critique a report to see what could have been done differently, or just to look through a report and we're able to see that certain things weren't considered. And courts don't necessarily just rubber stamp these reports. Some judges do more than others, but at the end of the day, yes, a custody evaluation where someone has spent the time and written an actual report and done their due diligence is very persuasive, but it isn't also like necessarily adopted by the court wholesale. I've had cases where the court has been like, okay, here's the recommendation. I'm going to take most of this. I'm not going to do that. And I'm going to do something totally different. Courts can do whatever they want. So they might look at it and say, I'm going to adopt everything the guardian ad litem said, or they might say, yeah, I don't think so. I only like part of it. I also had a case, actually, when I think about it, more than one, I'm thinking about one specifically at trial where the court basically said, I'm not going to give any weight to this report. Other times I've had a case at trial where the court said, I'm going to adopt everything that they want. So it's not a one size fits all situation. I know I said that earlier about other things too, but it really applies to evaluators. It's very important in your case too, to work with an attorney that understands who might be a good evaluator for your case. One evaluator for one set of facts might be more advantageous to you than others. So it's important to know who the evaluator is, if you need a guardian ad litem, or if you need the level of a parenting evaluator, if there are specific concerns, and who is a good fit for your case. So, I mean, sure, like I started out saying, there's always going to be someone that doesn't like the report. I mean, that's just kind of how it is. But there's usually going to be a need for something just beyond because I said so as to why a court should do what you want when it comes to a parenting plan. So I hope that is.
I have a few more questions, but you could launch into some
Go
other.
ahead. I'll take a couple more. It's fine. I'll take a couple more.
Okay. Can you build in flexibility to a parenting plan to allow for adjustments to perhaps minimize the impact on the child if they're having a hard time? Can you be flexible with the parenting plan potentially?
I mean, you can do whatever you want. Like I tell parents this, if you get along with the other parent, especially, you have to have a parenting plan to finalize your case, but you can put that parenting plan in a drawer and not look at it and just make agreements. You can always make agreements outside of a parenting plan. But a parenting plan is basically, it is a court order and it's basically the rules of the road if no one's getting along. So there can be some flexibility in there, but at the end of the day, there needs to be clear guidelines about what residential time is, unless the child's like 17 or something, because you need to know this isn't the child's choice. And that's a very big thing that comes up in Washington courts a lot, where we end up in these resist refuse situations where a child is refusing to go and resisting to go. And the parent's like, well, it's the child's choice. There is case law in Washington that makes it very clear that's not the case. A parent has an obligation to say, to do everything and to make every reasonable effort to get a child to go on their residential time. And you could be held in contempt. You will be held in contempt most of the time if you don't. So it's not like you can build something in that says if the kid doesn't want to go, they don't have to go. That would never be an acceptable provision. So there can be flexibility, though, in the sense that you could just say, hey, it's supposed to be my week. You want to take them? They're doing this or that? Sure. You can make any agreements that you want. Parties can always make agreements outside the parenting plan. But that's the key. It has to actually be an agreement. If it's not an agreement, you need something to fall back on. So yeah, but there's no right or wrong way to handle a parenting plan. I've seen some parenting plans with tons of extra provisions, which is good, but also can create more opportunities for conflict. The most important thing is to have no ambiguity when it comes to the residential time, the decision-making, what the decision-making protocol is going to look like, and then other specifics that are specific to your situation. Also transportation, having a very clear transportation protocol and drop-offs and who's going to do what is so important, because I see those things come up much later. Before I take one more, I want to make sure I'm getting through some of the things that people need to know about. A lot of people will say things like, gosh, this person is, a danger to our children. And, they shouldn't be, they just shouldn't be with our kids. And so then we start talking about, what really, you might not like some of the things that parent does, but that's very different than actually being able to have a limiting factor in a parenting plan case. So a limiting factor, you might hear someone refer to them as 191s. 191 is part of the statute that sets forth what factors are limiting factors. 191 factors are dangers such as abuse and addiction, DV, and there has to be a tie between any of those things and the emotional and physical safety of the child. So 191 factors could be child abuse, spousal abuse, drug or alcohol abuse, parents' substantial neglect of a child. There's any number of factors, but then there needs to be a tie-in between those and their ability to parent. So if you have a factor, what we would call a 191 factor, and it comes from, if you want to ever look it up, it's RCW 2609.191. And again, those 191 factors are dangers, but it can't just be like, hey, I think the parent's a jerk, I don't want them around the kids. There actually has to be a limiting factor to limit decision-making and limit residential time if you think one of those things is an issue. And it doesn't mean to say that a court still might not decide one parent has more time than the other without a limiting factor. That happens all the time. But it's important for you to understand what these factors are. So when you think about what those factors are, you need to think about, okay, here's an example. If you have a parent who has an active substance abuse issue, they've recently got a DUI, the kids were in the car, they are not safe to be home alone with the children, and they're not in any kind of treatment. Okay, maybe then when they're actively using, the chemical dependency addiction is a limiting factor. Or you could have a parent who has been in recovery for 15 years and has had no issues and, you know, has historically been just as able of a caretaker of the children, and then you're not going to have a restriction there. So it isn't just because I've ever had a substance abuse issue, I have a factor, you know. So there's a lot of different ways to look at it. There's two types of restrictions that are what are called 3A restrictions, which refers to the section in the parenting plan, and 3B restrictions. 3A restrictions, a 3A restriction is domestic violence. So if you have a domestic violence protection order enter against you and there's a finding of domestic violence, if you are convicted of domestic violence against the parent, or even if there is domestic violence that takes place in front of a child, those can be a basis for 3A restrictions, which can restrict your decision-making, must restrict your decision-making, as well as restrict your residential time. So I could really talk about restrictions pretty much all day. I mean, I'm not going to do that, but I could. It's just important for you to know that there needs to be a nexus between that issue and between the actual ability to parent. So, Melissa, I think there's more, so feel free to go ahead.
There's a question that we may need to disregard. It's mainly, it's not so much about parenting plans and child custody, but it's somewhat overlap, I guess. They're saying that they have college-age kids who are in college, and maybe one that's about to graduate and one that's in high school. Anyways, question is about I think it's kind of whether divorce would impact financial settlement and impact with the situations of kids in college and who pays for the kids in college and things like that. You know,
Okay.
how does divorce interact with that?
Yeah, post-secondary
more general than specific, right?
Yeah, post-secondary support deals with post-secondary is post-high school support that deals with kids in college. So first thing to know is if you have, most of the time what happens in your in your child support order is that post-secondary support is reserved if you have minor children, because you don't know necessarily what their situation is going to be, where they're going to go, what their needs are going to be, or what the financial resources of the parties are going to be. So it's reserved. And then someone has to move for post-secondary support and serve the other party with a request for it under a petition, either before the child turns 18 or graduates from high school, whichever's later. So that's very important for you to know. So if you don't do that, you foreclose, you absolutely foreclose the ability to seek it. So you don't want that. If you're in the middle of a divorce and you've got college-age children, then yes, you can make post-secondary support part of dealing with, the child support order. And a lot of the time, it depends on where your children are going, what the resources of the parties are. Sometimes, whether there's going to be an expected contribution from the child. It's not the same, but yes, you can deal with, and you will deal with who's going to pay for college-age children that are in college in the middle of a divorce. Otherwise, post-secondary support is most often going to be reserved and dealt with when it's imminent, because then you know more what you're dealing with.
Yeah, thank you so much. That's helpful.
Yep.
Okay. Does it reflect badly on a parent if they file majority residential time and decision making and without clear evidence? Does it ever backfire for frivolous claims, for example?
No, I mean, yes and no. Everybody thinks the other party has frivolous claims. A lot of times somebody's going to say they want majority of residential time. That's unfortunately, there's a lot of mudslinging in family court. I wish that weren't the case, but I would be lying to you if I didn't tell you that that was the case. If you ended up all the way in a trial and someone had made claims that were just ridiculous and terrible, and you had hearings beforehand where they didn't get what they wanted, you might be able to say the person was being intransigent, which means, creating more fees than necessary and basically doing things in bad faith. But you could probably say that in most family law cases. Everyone's going to read a declaration a lot of the time and say, oh, this is all lies, this isn't true. Well, then you have a chance to refute it. Nobody's credibility is an issue. It's actually very important. I tell my clients, don't make claims that aren't true, because it could damage your credibility with the court. But it can be very difficult to prove what's true and what's not true. So out and out lies that are obviously able not to be, are obviously not true. So if you said this person's arrested and they never were, different things like that. But if you're saying, oh, he always did this, he never did that, he yelled at me in front of the kids all the time, like, it's pretty hard to prove that's not true. So the court's kind of like, whatever. I mean, at the end of the day, credibility is important, and how you present to the court is important, and you can't really control what the other party's doing. You want to show if they're not being honest, but nobody's going to say that the other party's going to be punished if they said something that you don't necessarily agree with. I don't know if that makes sense.
Okay. This is a good question. At what age, or is there an age when a child has say over who they want to live with? So if a court gives custody to one parent and the child doesn't want to live with that parent, is there options for, switching custody? When does the child have a say?
Child never has a say. I know you're not going to want to hear this, but in some states, best the way to put it is this. In some states, there will be a situation where a child gets to say where they want to live, right? Like at what age can a child decide? In some states, they get to decide at a certain custody hearing. It's very rare for a state to allow a child to choose a parent, but sometimes, and have that choice be legally binding. That's the case in Washington. How custody is determined in cases with children who are under 18. A child can only choose to where they want to live when they're 18, when they're a legal adult. It's not up to kids. So again, this is what I talked about earlier. If there's a resist and refuse dynamic, and there's a reason for that, or there's abuse, the court might decide that, no, this kid never has to see this parent. But if it's just like, I don't want to be over there, it's also, oh, I don't like that parent makes me do more homework, or I'm more comfortable here, or whatever. And in Washington, a child doesn't get to choose what parent they live in, but they can influence the decision. There might be information that they say to a guardian ad litem, and that's the way that a child's voice comes into the court. But the answer to that is easy. A child never gets to decide. It's never their choice in Washington. So that's just not the law, and there's reasons for that, some of which I've outlined, and that can be very frustrating to people, but it is what it is. So, and actually, when you talk about looking bad in court, the more that you involve your child in litigation, the worse it makes you look in a Washington court. The more that you have discussions with a child about the other parents, and if your child tells a guardian ad litem, oh, well, dad said mom XYZ, the more that comes out, the worse that you're going to look. The basic principle in Washington and many other states is to leave your children out of discussions about litigation and residential time. That's something for a parent to decide, not a child.
Okay, another question here. If a spouse has left and immediately moved in with a new lover and is now pushing to have the kids stay with her and this new partner, and the kids don't know the person, is that limiting?
No. No, okay, and a lot, and again, these are introducing children. A lot of times people will want restrictions on intimate partners in their parenting plan. Like, I won't introduce a child to so-and-so until we've been dating for so long. You could seek a restriction like that, not a restriction, sorry. You can seek language like that, but courts are rarely going to put those in because it's kind of like child's at parent's house. They get to do what they want. They get to introduce them to who they want. If you have a situation where parent A has been bringing in a bunch of different people and the children's he's met like 5 people in the year and they're really confused, that's one thing. It's basically a good principle not to introduce new partners until your divorce is final, unless it's dragged on for years and the party's been separated for years, and maybe that would be different. But unless there's a real concern about that new partner, like they have a history of sexual abuse or domestic violence or something like that, or there's a CPS finding against them, then there's probably not going to be a restriction on new partners meeting or spending time with your child. So.
All right. Do you want to take a couple more, or do you have some more?
I will, we don't have a ton of time, but I'll take a couple more. I'd rather answer the questions. And then I do want to talk about decision making.
Okay. Well, this is a question about decision making. What happens when decision making is impossible between unmarried parents? Can sole decision making be accepted to avoid unreasonable mediation costs? What alternative methods could be used to allow for more timely decisions when people are just struggling?
No one's going to say you get decision making because so you don't have to pay for mediation. That's not going to happen. Let's talk about decision making in general, but it is also important for you to know if there is a history of what I would call abusive use of conflict, or domestic violence, or other just high conflict behavior when one party has been completely unreasonable and there's a reason for that and that's documented. You might be able to get sole decision making based on that. But let's talk about decision making in general. Unless there is a basis for restrictions, or sometimes in a long distance plan, one parent won't have decision making on certain things because it makes more sense for the other parent to do it, like non-emergency medical. But there's generally going to be a principle that the two of you are going to make decisions together. And it's going to be very important in your parenting plan that there's an internal process for that. I really like it because what always ends up happening, I see plans like this all the time where it's like, okay, we're going to make decisions together, but it doesn't say how. And then one parent will say, the other parent's not responding. And I needed to sign this kid up for summer camp, or we're going to lose the spot. And so it's really important that you have a protocol that talks about how it works. Parent A proposes the decision to parent B, and they say the cost and what it is. Parent B has a certain amount of time to respond and say, I agree, great, or I don't agree. Do I not agree because it's financial, or do I not agree for some other reason? And then perhaps you'll have something in the parenting plan that says if it's just financial and parent A wants to pay for it, they can go ahead with the decision. Or if they don't hear from the other parent at all and 72 hours or whatever have passed, that person gets to go ahead with the decision. So someone's non-responsiveness can't hold you hostage. Things that are subject to decision making, the most common ones that become points of contention are non-emergency medical, which can be things like especially therapy for kids, providers, changing providers, orthodontia, anything that's not emergency, because when a child's with you, you get to make decisions, day-to-day decisions. And if there's an emergency, you don't have to wait and call the other parent and say, can I go to the ER? You just obviously go. But non-emergency medical is a big one. Extracurricular activities are another one. There is really, and a lot of this is you can't obligate another parent's financial resources or residential time. So the idea is not to do that and to have those things to be a joint decision. There's other things too. Some people will choose to make it cell phone usage. Some people will choose to do, things like that. I kind of think the more that you can allow control in each parent's home, the better. The less that you can have things that are overlapping and micromanaging, the better. But, tattoos and piercings might be one, but the big ones are really non-emergency medical and extracurriculars. So some people will make every single thing difficult. I think you have to have, unless there is if there's domestic violence, you don't have to have a decision-making protocol that includes alternative dispute resolution. You can just go right to court. Sometimes some people will just want to go right to court. It's usually better though to have what we call ADR, alternative dispute resolution protocol in your parenting plan. That's either going to usually be mediation or arbitration. I am a big fan of and firmly believe that in most cases, arbitration is much better for two reasons. One, it's going to get you a decision a lot faster. And a lot of the time when you don't agree on a decision-making set of facts, you need a decision like sooner than later. And then two, it's going to be like less expensive. Mediation, you'll have to go to a mediation, and then there's no guarantee that you're going to get a resolution. And then you'll either have to go to the family law motions calendar, or you'll agree to submit the issue to arbitration. Sometimes people will have a plan that says mediation will be attempted first and then arbitration. That's fine too. But I think for ease of scheduling, getting something done and getting a decision and having it be cost effective, arbitration makes the most sense. Typically on written submissions. Hey, I want to sign John up for soccer. Hey, I don't want to because I don't like the schedule and I don't want to have to drive him to practice. Okay, submit it to arbitration. Each party submits a written statement to the arbitrator that's named in the parenting plan about why they think and what the situation is. And then sometimes the arbitrator will have the parties respond to each other's sides, and then the arbitrator makes a decision, and that can happen very quickly, and it's a lot more cost effective. So that's a little bit about how decision-making works in a parenting plan. And I also think that, you know, if you're talking about having sole decision-making, that definitely happens. I actually have a case where my client was first divorced in, I think, 2017. They had a 50-50 plan with joint decision-making after a guardian ad litem report. It was pretty clear that wasn't going to work. So eventually my client modified the parenting plan, became the residential parent, and received sole decision-making. But there were a set of factors that if the other party does these things, engages in, they had a parenting coordinator too, engages in certain classes, doesn't have any issues with the parenting coordinator, then eventually they can again get joint decision making. So there's a lot of different ways that you can position and deal with decision making. But I'd say the big takeaways are have a clear protocol. I think consider arbitration rather than mediation to get more cost effective and fast decisions. So I hope that helps.
Okay, another question here asks about what about covert neglect or abuse? There's a situation, and it's probably too fact specific, but maybe we can work around it and just talk more generally. Basically, they're saying there's emotional abuse of two of their children on record with a therapist, and they're trying, there's not limits or restrictions, but they're trying to ask for language that says, you know, the kids can call and leave if they feel emotionally or mentally or physically unsafe, asking that the father seek counseling. It's being contested. I don't know. I think they're just trying to figure out kind of what can you do when there is this potential covert neglect or abuse to
You
ensure this.
probably need a custody evaluation. No court is going to be like, you said that, so that, I mean, not no court, but for the most part, unless there's a documented history, you need documentation.
I mean, if
Okay.
there's a therapist making a statement,
Yes.
is that enough?
Yes, you need documentation. But as you know, Melissa, a lot of therapists are not willing to make a statement or write a declaration for the court. So the way that that comes in is through a custody evaluation when a therapist talks to a guardian ad litem, and then that's reported in the guardian ad litem's report. Some therapists are willing to and able to be fact witnesses for you and say this is what happened. Many, many, many are not. So, but documenting through therapist notes and records or a conversation between a therapist and a guardian ad litem is a way around that. So what the kind of things you're talking about, you need documentation. Like you need documentation, whether that's through a therapist, whether it's through, even sometimes somebody will interview. I hate it when people say this, but I get why they do. Oh, well, my ex is, such a narcissist, and they'll just charm the evaluator, and the evaluator will just think that they're great. Well, that's what these people do. So sometimes, sure, that might happen, but a lot of the time, you got to give these evaluators a little credit that they might talk to this person and they know the questions to ask, and they might think that some of the things they say are not appropriate. So that can be a good thing for you to help you, but you need documentation, or you need a situation where, sure, the court's not going to talk to your child, but an evaluator is, and they're going to say, mom did XYZ or whatever. They're going to know how to read what the child is saying. So you need documentation. That's the best thing I can tell you. And it can be difficult. I mean, I'm not saying it's always easy. It's not, or things would be a lot more clear cut in family court than they are. But I would highly recommend documentation. That's the best way to do it. And sometimes that's an evaluation. Sometimes it's through, also too, I've had situations where someone will report something to a pediatrician, and the pediatrician will make observations and make notes, and we're able to use those notes. But it's very difficult. You'll need a pediatrician to sometimes, or any other provider to sometimes at least authenticate those notes. So there's a lot of different things that come up, but documentation is the key anytime you're making claims, is what I would say.
And then on similar lines, what is the definition of abusive use of conflict according to the court? Is that a thing?
Yeah, and okay. I would say if you really want to talk about abusive use of conflict, it can be difficult to understand. So I'll talk about it for a minute. There's an issue that often comes up, and it's less understood by people than probably any other basis for restrictions. It's abusive use of conflict. This is, I call it a phenomenon that refers to a situation where one party in a family law dispute intentionally fuels drama and creates conflict, leveraging what I would call like the inherent adversarial nature of the legal system. So obviously you guys are pitted against each other in a divorce. You don't want the same things most of the time. So sometimes someone will intentionally drive conflict to inflict emotional or financial harm on the other party. Abusive use of conflict often happens in not just divorce proceedings, but maybe a parenting plan modification and other family law cases, usually by individuals who are unwilling to compromise or use conflict as a means of trying to have power or control. It's really important to understand the nature of this and the potential impacts. It's not always a one size fits all. Again, I've said that a few times, but that's just really true with family court. Abusive use of conflict goes beyond like a common disagreement. I don't agree about soccer, like I mentioned earlier. It's an excessive, like continual focus on fostering conflict that disrupts the legal process, exhausts the other party emotionally, financially, or both, potentially harms children involved. It can be manifested through, I would say, a variety of behaviors, including non-compliance with court orders, constant legal maneuvers that prolong a case unnecessarily, consistent refusal to cooperate in co-parenting arrangements. It's, again, when I talked about documentation, if you have somebody that's high conflict, our Family Wizard is really the best place to go. And our Family Wizard is a parenting application where you have your communication in there. So you're going to know if the other person read the communication. There's going to be a clear record of the communication. Courts are very familiar with it. You can give an attorney or a custody evaluator access to it. But when someone is just saying no for the heck of saying no over and over again and making every single thing a problem and there's no rational basis, they could be using an engaging in abusive use of conflict. There's remedies for it, but it can be very, very difficult. Dealing with someone who's engaging this kind of behavior is challenging, but certain strategies can kind of help you alleviate that. Having an experienced attorney that understands the complexity of that is really, really important. Maintaining, again, this is what I was talking about earlier, maintaining comprehensive records and documenting the violations, keeping a journal is critical, and also trying to hold the other party accountable for non-compliance right away is critical. So something like this doesn't get out of control. Also seeking support from a mental health professional. You really need somebody, you're going to keep your attorney fees down and you're going to be showing that you are the person taking care of your mental health. If you're dealing with someone like this, and they can also help you with coping strategies for you and any kids and managing the emotional strain that comes with it. And then if you end up in court, it also shows that, you know, you're taking care of yourself, even if the other party is going off the rails. So abusive use of conflict, that's it in a nutshell. But it's a difficult situation. If you find yourself dealing with that, you should get help because those people won't stop. They just won't.
Mm-hmm. So. Yeah, I mean, there's a follow-up question on that. Another person's asking if withholding financial support to leverage more time with the child, could that count as abusive use of conflict?
I mean, yes and no. I mean, really what's appropriate there is that if you have a child support order and someone's not paying it, then you need to hold them in contempt of the child support order. It's more of a specific situation like that. So I hope that makes sense.
Yeah, and I think we got through most of these questions. So if there's any other information you want to deliver before we wrap up.
There are. I mean, I want to just stress to everybody again that the best interest of the child determines custody in Washington. Not what's better for a parent, but what's better for a child. That might result in a 50-50 parenting plan, but not necessarily. The court has really two concepts too that help guide them, like preservation of the status quo and a final parenting plan. So if you have a temporary parenting plan, then it can be very difficult to show why that should change. So sometimes a temporary parenting plan is super important, unless it's going to be a parenting plan that's going to be phased in over time, like we talked about earlier with developmental ages or needs of the child. And the court needs to determine who's the primary parent, right? So the primary goal in a Washington State parenting plan is really to preserve stability and create stability for children. So that there's a broad different number of agreements that can be made. I'm not going to say this is the best parenting plan every time, but stability in the parenting plan and the residential schedule is paramount. The second thing is what we talked about a little bit earlier. Absent any special circumstances, courts usually order joint decision making. So special circumstances can be restrictions, they can be abuse of use of conflict restrictions, any other restrictions, they can be long distance parenting, not always too. A lot of the time with long distance parenting, there's joint decision making, but bottom line is absent special circumstances, joint decision making is probably going to happen. So it's important for you to know that. Special circumstances that affect custody, these are the restrictions that we talked about earlier. If a parent has a drug or alcohol impairment that impacts the ability to parent, that could be something. If a parent has engaged in neglect or abandonment, if a parent has domestic violence findings and is engaged in that behavior, there's any number of factors like that are fact specific, but that can really impact custody. So the main things for you to know is the parenting plan is going to be what's best for your kids. And that's might not be what necessarily you want, but you're going to have to think about, where are you living? Where is the other parent living? What makes sense? How old are your children? Where are they going to go to school? Who's going to take care of them after school if you're working? You have to have a plan. And so the more that you can have a plan and that you can be realistic about what you're asking for, the better off you're going to be. So I hope that helps. I could talk about any number of other things that we didn't get to, but I think we did touch on a lot of things. You guys asked really good questions too. And I always think when you ask questions, that's good because it lets other people hear about real world situations and we're able to talk more about things that might be helpful to you. So I hope that helps. Feel free also to check out our webinars. I've got probably other custody webinars I've done over the last years. You can go to our website at dellino-law.com. You could go to news and resources and you could go to our YouTube channel. We don't have everything up there, but we are steadily getting things up there. There's a good number of webinars up there. If you want to learn more about it, you can also schedule a consultation. There's any number of things that you can do that would be helpful. And I'm not just saying schedule one with me or my firm. I don't really care who it is. Schedule one with somebody if you have questions, like whoever you're comfortable with. You should do that because it's important for you to know, this is what I'm dealing with, and this is what could or might not happen. And sometimes the sooner that you get ahead of things, sometimes we'll have clients where I tell them you should do something now, and then they don't, and it's 6 months or a year later, and they wish they had because the other party acted first, and now they're on the defense. And I hate it when that happens to people. But here's the last thing I'll leave you with. People think about divorce and separation for an average, the studies show an average of 2 to 3 years before they do anything. So if you're in the early stages and you're thinking about, what do I do? Where do I go from here? And you aren't ready to pull the trigger, that's totally fine and normal. I'm not saying everybody should file for divorce or whatever, but I am saying starting that process and thinking about it, getting a consultation early on from someone can be helpful because then you can understand what you might be dealing with and whether you should take action now or not, because you might be foreclosing certain possibilities by not doing that. So anyway, when it comes to custody, it's stressful. It's not anything I wish for anybody to have to deal with, but it's a huge part of family law. Anytime you finalize divorce, you have to have a parenting plan. And you have to have a child support order and you have to have child support worksheets. Those things are necessary. So you are going to have to deal with it one way or the other. And the more that you can get ahead of it and the more that you can be realistic and present yourself as level-headed and looking out for the best interest of the children, the better off you're going to be. So I hope that helps. Take care. Thank you for coming. Have a great day. Bye-bye.
Thanks, everyone. Just leaving our slide here for a moment with contact information for Michelle and the Dellino Family Law Group. If anyone's interested in counseling services related to any of these topics, please reach out to me as well. And we hope to see you next time. Take care.